everyone. Happy Friday. It's another Friday where the weather is getting a little bit warmer. And we're getting more vaccines. So we're kind of excited that there is a light at the end of this tunnel. I wanted to welcome everyone again to tonight's Zoom webinar. For those of you who are joining us today for the first time, we regularly hold these webinars every Friday, and we try to adjust to the need, the environment. So today, I am very, very honored and proud to introduce the man that's going to tell us what is a J51. Tim Collins with Collins, Topkin, and Miller. Tim, for those of you guys that do not know Tim, he is a wonderful tenant attorney. He only represents tenants. Tim is the attorney that actually helped our grassroots tenants associations. And he's also the former executive director of the Rent Guideline Board. And we're very happy to say that Mr. Collins is truly a partner of our organization. And without further ado, Tim, I think, we're really excited to find out what is a J51. And that would let us know whether or not we're going to be rent stabilized or not. And so I'll, without further ado, I pass it on to you, Tim.
Thank you, Elcia, and thank you, Palante, for hosting this. And as Elcia knows, we've had connections going back, I don't know, 8-10 years now. It seems like an awful long time, and Palante has grown over the years and helped out innumerable tenants. I'm always delighted to pitch in where I can. The law around J51 is in some flux, as is the administration. So I'm going to concentrate on the basics and try to walk you through what the basic law is and how it's important that you understand the basics so that you can identify whether or not you are actually rent stabilized, possibly entitled to a significant rent rollback, and possibly even a rent overcharge award. These things have changed over the years, so we kind of have to follow the process a little bit. J51 is a program. It's administered by the city of New York, and it was designed to create incentives for owners to invest in capital improvements in their buildings. Things like boilers, windows, plumbing, electricity, and roofs allowed an owner to get a special tax abatement, basically to help finance these investments. But along with that tax abatement, the way the law was structured, the plain language of the law was structured to place the units under rent stabilization. However, going back to the mid-1990s, the New York State Division of Housing and Community Renewal, we're just going to refer to them as DHCR, took the position that the J51 did not necessarily require rent stabilized status for buildings that were otherwise not rent stabilized. So it really had very little consequence for a number of years until a very enterprising law firm made a substantial investment. It wasn't my firm, but they made a substantial investment in a class action lawsuit because they read the law correctly. And they recognized that the state agency that was supposed to have administered the law correctly had not been doing so. Through a significant long-standing effort, their case made it to the New York Court of Appeals, the highest court in the state, and the New York Court of Appeals agreed with the attorneys that, in fact, DHCR had read the law wrong, which meant that tens of thousands of apartments that were previously not recognized as stabilized, but were receiving J51 benefits, now came under rent stabilization. And the case was Stuyvesant Town, involved Stuyvesant Town tenants, Roberts versus Tishman Speyer. And it was concluded in 2009 and ultimately resulted in a settlement agreement around 2012. But the upshot was that all of these tenants who for many years had been treated as being open market tenancies, no rent stabilized leases, no right to renewal leases, in many cases massively overcharged, all of a sudden discovered that not only were they rent stabilized, but they had been rent stabilized and they had a right to look back and seek overcharge overcharges for the previous 4 years. That was the old rule. Gets very complicated. I don't want to go into the weeds too much, but if we move forward, we now live in a situation since 2019 where a unit that was stabilized as of June 14th of 2019 should remain rent stabilized if it had come under the J51 program. Now, here's the difficulty. And by the way, this applies not just to buildings with 6 or more units, which is the cutoff for rent stabilization in general. It can have fewer than 6 units and still be rent stabilized if the owner benefited from J51. If the building had not been rent stabilized at the time it entered into the J51 program and came into the stabilization solely by virtue of J51, and very important, and the owner provided notice of the J51 protection or application of the J51 program with the initial lease, if it's a new tenant, and with each rent rider that occurred thereafter, then the owner can come out of stabilization, or could come out of stabilization, before the HSTPA in June of 2019. After June of 2019, any unit that was stabilized as of June 2019 should remain stabilized. Now, some of these things are still coming up through the courts, and they're subject to challenge. I'm dealing with a massive challenge right now involving over 4,000 units. One of the arguments being made is that if the unit would have come out of stabilization under the J51 program before June 14th, 2019, but didn't, if the unit now comes out, their claim is that it is completely destabilized. Our position is that's not the case. Everything remains stabilized now, if it was stabilized on June 14th, 2019. So you have a couple of questions. First question is my unit rent stabilized? And so you either know that based upon your lease, and the major criteria for stabilization are 6 or more units constructed before 1974, or otherwise benefited from the J51 program, or if it was new construction, it would have benefited from the 421A program, which is similar to J51, but really applies to new construction, which we're really not going to talk about today. We're really focusing on J51. So you ask yourself, am I rent stabilized? If your conclusion is, I don't know, I don't see anything that indicates that I am rent stabilized, then your next question is well, how can I find out? Well, the first step you should take is to get your rent history. And I know Alcia Palante does this a lot for a lot of tenants. There are ways to get your rent history on the phone. You can do it by mail, and you can do it by, on the internet with DHCR. I don't know, Alcia, did you want to say a few words about that?
Yeah. So at the end of the session, we could put the phone number where they can call.
Okay.
And Robert has a slide so that they can call and get a copy of the rent registration history, which gets mailed to them free of charge. And then once you get it, if you guys scan it or mail it into us or call us, the idea is to get it to us. We can help you analyze it, looking at your first lease, your current lease, and the rent registration history. And I think, it's important to always ask for the complete history, because sometimes when you ask the ACR to send you a copy of the rent registration history, they would only send you 4 years or 6 years. So it's always good to say, I would like to get the full history from 1984 to present. And they'll mail it to you, or you could pick it up. But right now with COVID, it is best just to get it mailed to you, and you'll get it like in 4 to 5 business days.
Right. And that's really always the first stop. You want to have your lease. You want to understand, what is the relationship, as I understand it, with the owner. But then you want to know what the state agency has with respect to where your apartment has been in the past. Now, sometimes you may be rent regulated, and it doesn't have a J51. There may be other things in your rent registration history where the owner illegally took it out of rent regulation. Now, one longstanding, painful barrier to determining whether there was fraud or there was some illegal act taken in the past is something we describe as the 4-year rule. And under the 4-year rule, before June of 2019, you could not look at the rent history that predated the 4 years prior to your filing unless you could show that there was some indicators of fraud. Now, that's still the case, but you have to establish fraud. In the Housing Stability Tenant Protection Act of 2019, the state legislatures took away this limitation on examining the past rent history and expanded the period for the benefits of an overcharge, for an overcharge award, to 6 years, and made some other changes. The problem is that the New York Court of Appeals last spring declared that unrestricted look-back period unconstitutional as a violation of due process. Very long, complicated explanation, but the consequence is that if you are filing today, you can look back to 4 years prior to June 14th, 2019, which is June 14th, 2015. And as time goes on, your look back is going to be 6 years back. But for right now, if you're filing today, June 14th of 2015 is the date that you can go back to. Again, and importantly, unless you can show that there was some active fraud by the owner, it's not so easy to do, but it's doable in some cases, in order to take your unit out of rent stabilization. Having a fraudulent tenant or an illusory tenant in the apartment, falsely registering somebody who never lived there is an indicator, that kind of thing. So that's the standard analysis. Now, let's say that you look through it and you see, okay, it seems to have been exempt for the last 10 years or 7 or 8 years. And there's no record, or maybe there was never a registration. There's no record at all. Then the question becomes, should this apartment be rent stabilized, treated as rent stabilized under the J51 program? And unfortunately, like everything else in this business, this is where it additionally gets complicated. There was a time when you could do something called the J51 lookup. I think until very recently, as I understand it, that is no longer the case. I just tried to do it actually for one of the properties I deal with, and I was unable to get into the system. And I know, Alcia, you've run into this, and I've seen it most recently on a list of attorneys who were talking about their frustration with doing the J51 lookup. So now we're in a situation where you've gotten your rent history, you've looked it over for fraud and other sources of overcharge complaints, and you're asking yourself the question, should this be rent stabilized by virtue of J51 or 421A, which again, we're not going into in detail. So to take that next step, at this point, probably the best thing to do is to call Palante and have them help you go through the steps of determining whether or not J51 applies to your building. And if J51 does apply to your building, then you are probably rent stabilized, because if you're coming to Palante and you have no information about the stabilization status, and you discover that it was J51 or benefited from J51, that means that the owner did not give you the required notices. So not only would you be stabilized for the duration of the J51 period, but now on 2 arguable grounds, you are stabilized for the rest of your tenancy. The first arguable ground, which I mentioned, was the fact that you did not get the notice. And the law says if you don't get the notice, you're protected for the rest of your tenancy. The second ground, which I've talked about, which may change with court rulings, is based upon the new Housing Stability and Tenant Protection Act. Insofar as if you can establish that you were stabilized on June 14, 2019, it's our position that you remain stabilized. Now, the basic reason why we take that position is that the law explicitly allowed 421A buildings to come out of stabilization if the proper notices are given. But it didn't, in the correction bill, it did not mention the same off-ramp for J51 buildings. So we're hopeful that we would, as long as we can nail you down on June 14th, 2019 as having been stabilized on that date, whether you got notices or not, there's an argument to be made that you're still stabilized. Okay, so then what
Can I ask you a
happens?
question? So
Yeah,
I have a quick question. So for these J51s, this is kind of like comes like in the form of a lease rider, right? As part of the lease,
yes, yeah.
and it says J51 on it. Now, what about if you moved in and there was no J51 lease rider, and then your
Mhm.
lease renewal, which will be, regular, vacancy lease that the owner would give, he includes a backdata rider. Should tenants sign that, or the tenants should just say, no, I'm not going to sign it?
Well, if it's backdated, then you shouldn't have to sign it. The
Okay.
law is that they have to put it in your initial lease as well as every single renewal. If they miss a single renewal, then they have not given the appropriate notice. But again, Alcia, it may be less of an issue than it once was. This used to be a huge
Hmm.
issue, but it may be less of an issue than it once was, because our position now is that everything stays stabilized, whether you got notices or not, as long as you were stabilized on June 14th, 2019.
Great. Thank you.
Okay. So where does that leave us? So you're going to go through the basic steps. Look at the information you have, your current lease, whatever written agreement you have with the landlord. Um, what are you being charged? You're going to order your rent registration history. You're going to look through the rent registration history to determine whether or not there may be any other basis for an overcharge. And with that, you may need some assistance of an attorney, maybe Palante can help you out, but there are folks who deal with this stuff and can spot, funny business when it arises. And we're also going to have to consider whether or not the stabilization is a result of fraud or a result of, some other error on the part of the owner. If it's arguably the result of fraud, then you can look at the rent registration history well beyond, you can go back to 1984 when the system started to determine whether or not, you've been overcharged. Now, the new law said that in setting the new rents, if you were overcharged and it was a fraudulent registration of sorts, the new law said in setting the new rents, you would go back to the last reliable rent on record. The Regina case that I just mentioned has kind of thrown that up in the air and left us in a position where if you can establish fraud, you go back in the past, you have no reliable rent history, then DHCR may apply something known as the default formula. Now, there are different ways they can do this, but fundamentally, the default formula is to take a look at the lowest rent regulated apartment in your line or in the building or a comparable apartment, and that would be your base state rent. Now, sometimes this is not much of a difference. Sometimes it's difficult to identify because you don't have access to everybody's rent roll. And sometimes it can be fabulously beneficial. I've seen rents go back several $1,000s because they go back, typically it's an, older, elderly rent stabilized tenant in a comparable apartment who's been there for 30 or 40 years. And so their rents have not been increased by a lot of vacancy allowances, and they have a fairly modest rent. And then, by applying the default formula, you can ask for, damages, which is the difference between what the rent should have been or what the DHCR sets the rent at and what you actually paid. In addition, under the new law, you can actually, there's a further look back for treble damages. And there is a presumption that overcharges are willful. However, another complication, none of this is simple. Because the J51 rent stabilization coverage was not recognized by DHCR for many years, the courts for a very long time took the position that overcharges based upon a faulty assumption that they did not have to recognize rent stabilization are therefore not willful, and they're not fraudulent. It was just an error that the state agency itself made. So the courts were kind of protective of the owners, recognizing, well, this could have been an innocent error. We relied upon the state, the DHCR's position. Our position is the Roberts case was decided over a decade ago, and the owners have had all kinds of outreach and notice that if you have a J51 tax benefit, you are subject to rent stabilization. Our position is if an owner in this day and age, in 2021, is not recognizing your rent stabilized status while a J51 is in effect, or if one was recently in effect while you were in occupancy, that is per se fraud. And I would take the position that it is just unreasonable and it's frankly unfathomable to think that an owner would not recognize their obligations at this point. Now, in 2016, DHCR did a review of J51 records and tried to identify all of the buildings that had listed J51 benefits with the city's Department of Finance, and checked to see whether any of those buildings did not fully register their tenancies. And if there were 2 or more tenancies that were not registered, those owners were supposed to get notice that they had to register, and there was a system to go about registering. So the number of instances where owners of J51 buildings are running totally renegade operations and not recognizing the tenancies as stabilized has fallen, but it's not non-existent. You could be living in one of those buildings. They're still out there. And again, our position is because it's such an egregious abuse this late in the game when they've had so much notice, then we would claim fraud. We would claim ask for the default formula to be applied, and we would claim treble damages. So that is the basics. I don't know if anybody wants to go into a little further. I can certainly take questions.
Well, Tim, I think that when it comes to these J51s, a lot of folks are unaware. Now, I'll talk about one case study that you and I worked on together, actually, which was that one tenant found out that they were, in fact, they actually had a J51 in the building, and they spoke to the neighbors. And literally, it was a very simple case in the sense that the minute that you knocked on the landlord's door like, hey buddy, you got to get these guys rent stabilized leases, the landlord folded right away. Am I right? And he gave everyone rent stabilized leases.
They pretty much fold right away.
That's a big level of protection, the rent stabilized leases.
Yeah, they fold right away now, but where the battles occur is that they fold and then they'll roll the rents back to where they were 4 years ago, or now to 2015. The problem is that our position now is that the default formula should apply in these cases, that the rent should be rolled back even further, and that these tenants have substantial overcharges. And what you find in improving these cases, improving willfulness and improving fraud, is that it's very important to get access or to review whether or not the same owner or the same management company was involved in prior J51 overcharge cases. Because if John Smith's management company has 3 cases that went to Supreme Court where they were found to have overcharged tenants because they refused to recognize stabilized status in a J51 building, then you can say, that this management company had clear notice of their obligation, and it's inconceivable that they were not acting willfully and fraudulently in failing to recognize stabilized status in any other building. And in order to do that, sometimes, and I think in most cases, we generally recommend that our clients go to state Supreme Court as opposed to DHCR, And going to Supreme Court requires a lawyer. It's expensive. It's a little bit involved, but there are certain advantages. DHCR is horribly slow. DHCR is an administrative proceeding where you do not have what's called discovery rights as of right. Discovery rights could mean the ability to file interrogatories or to demand documents or to demand depositions of managing agents or other officers of the owner corporation, or if it's an individual, to speak to the landlord, him or herself. If you get that and you get them under oath, then you can ask them about their background and history with J51 cases. And, if they lie, obviously it's perjury. But, if you get the documents and they disclose properly, and their lawyer, if their lawyer is an honest lawyer, and most are, will disclose that, this individual had in fact been involved in J51 cases in the past. And once you establish that, you should be able to basically serve up the willfulness and the fraud to the judge on a silver platter by showing that indeed in a deposition transcript, in an interrogatory, or in actual documents of prior cases, this owner was well aware of their obligations under the J51. So there's no way to wriggle out of a claim of willfulness or fraud. And again, it has a huge impact on what you can prove and how far you can look back, and what the base rent is that you establish.
Yeah. I think also that, when folks look at the rent registration history, they should also remember, Tim, and tell me if you agree, that just because the landlord submitted this report, right, this rent, supposedly that
Right.
someone lived there, doesn't necessarily mean that it's true. And once you look at the thresholds in terms of where, who paid what amount of rent, and the threshold during that time post before 2019, I think it's important to really review it. And in the sense where you probably owe mail that you receive from in that apartment from people that used to live there, and so forth. And so I think the key thing is that if you want to find out if you are rent stabilized, meaning that you don't have a rent stabilized lease, the first step would be to obviously go to DHCR and get the rent registration. But I think past that, you should really contact other organization or any other group or any other attorney, so that someone can really help you analyze what's there, and then take the step further, because since the J51 has been such an eye opener for a lot of the tenants that had no idea that they were actually rent stabilized, I find it very curious how the data is was available, then it became a little bit hard to find, and now it's like
Right.
super hard to find. So the regular person, like anybody on this call today, would have been able to find whether or not when they moved in they had a J51, but they moved the data under the impression that it was going to be a better system, and it really made it more difficult. So it's important, guys,
Right.
everyone here, if you want to know if you're rent stabilized, you got to do some work. And we're here to help you determine whether or not you're being taken for granted by the landlord, or whether you should have a rent stabilized lease. I see that there is a question, Robert, on from Gretchen. Is a
Yes,
non J51
it's a
question, but I think,
non-J51 question. That's right.
yeah, but I think Tim can handle it.
Can you please explain destabilization with the note in quotation exempt high rent vacancy improvement? I see that on my RHR in 2005, when the previous lease amount was 1,324, there were no permits pulled for this building / unit during that time. So significant improvements seem unlikely. I believe several units in this building were falsely destabilized during this period.
And what was the year again?
2005.
Yeah, that raises a couple of really good issues. And the problem is that if improvements were the basis for deregulation, and it's outside of that look back period, which now goes back to 2015, as I mentioned, June 14th, 2015. You probably can't use that information to establish fraud or an illegal overcharge. Now, with respect to high rent improvement deregulation, that simply means that the apartment had exceeded what was then, I'm pretty sure it was a $2,000 threshold upon vacancy, and going above 2,000, probably as a result of vacancy allowances, as well as improvements made in the apartment. And at that time, it probably would have been 1/40th, depending upon the size of the building. So the owner would have had to put probably about, $25,000, $30,000 in improvements at that time. The problem is you can have a great case showing that there is no, evidence that they did any improvements, and they have no, documentary backup for those improvements. But if it is outside of the look back period, you're going to have a real hard time. There's a Court of Appeals case which basically said, that you don't have to go back and analyze past improvements with a microscope if they were outside of the look back period, which was then 4 years, and now it's been stretched out to 6. But it because of this Regina case, really goes back to 2015 at the moment. Yeah, it sounds like they simply claimed that they did a lot of work in the apartment, that it was above the vacancy deregulation threshold as a result of both the work and the vacancy allowances, and it became destabilized at that time. Those are very common questions that we get at my firm. And unfortunately, the common answer to that is that it's probably not something you can do much about at this time. You'd want to look at that rent history more closely to see if there's something else in there that's, in combination with this claim of improvements, might suggest a fraudulent scheme. Like, for example, if there's a tenant that was supposed to, that's named there, Joe Smith is in there in 2007 and 8 or something like that, and no Joe Smith ever lived there. It was somebody else, or something along those lines. You want to look for some kind of irregularity. I've had cases where owners have renumbered the entire building and refiled their registrations under the new apartment numbers. Yep. So in this recent case, the tenant can only go back to the point where it was renumbered. I think it was around 2010. So we were able to argue in that case that this had to be a fraudulent scheme, because the renumbering really served no purpose other than to bury the rent registration history to prevent tenants from looking at what really went on. And in that case, the renumbering coupled with improvements that were never really made gave us a sound basis for putting pressure on the owner, and ultimately resulted in a settlement.
I'm very happy that you mentioned the renumbering, Tim, because we're seeing a lot of that. Mm-hmm. In fact, when we call on behalf of the tenants to get the rent registration history, we ask for number sequence. So it's like, hey, do you have an apartment? Let's say if your apartment is 1A, but would you happen to have a registration for A1, just in case? I mean, I don't think it hurts. And we have seen what you're saying. We've actually seen that, even to the point where landlords put a 0 before the number and then the letter. So it's always good, when you have a warm body at DHCR, meaning if you're calling in for your rent registration history, it would not hurt to ask to see if there are other rent registration with a similar, because we have been able to retrieve them.
Yeah, and if you get a rent registration history that goes back 10 years and then seems to go over the cliff and there's nothing there, or it was registered at some point, but then for a long period prior to that, there's no registration, then you may have something to look at. This is why there are many, many different nuances in reading a rent registration history that may jump out to somebody who deals with this regularly, where you may have a better chance of spotting some kind of fraud or corruption of some kind. So that's why it's useful if, unless it's crystal clear and you've, thoroughly vetted the issue of whether it's got a J51. If you have questions of any kind, you probably should speak with someone at Palante to look at it more closely to see whether there might be something else going on that you might just not be familiar with.
And I think also going back to the lease writer, what we've seen in fact one landlord in El Barrio in East Harlem that lots of properties, and what we found was that the landlord was trying to, in return for giving the rent stabilized tenants a lease renewal, he was trying to force them to sign backdated J51 writers.
Hmm.
And that
Hmm.
was something that when it got to our attention, we actually had to report it to the tenant protection unit at the HCR. And there was a full investigation, and the landlord got a cease and desist love note, said that those actions are unlawful. But I think, with everything that's happening today, and landlords, even with COVID, the landlord's going to get hungrier, they're going to get more aggressive, because they always say that they cannot, make ends meet.
Right.
So, it's important that you reach out to organizations like Palante, you reach out to attorneys. I mean, Tim you're an expert on this stuff, right? And, people can have access to you also by calling your law firm. But I think it's important that we do our due diligence and do not sit back just assuming that, oh, we don't have a rent stabilized lease, so it's okay. I mean, there are ways around it, and feel free to give us a call if we could be of any help. But one thing for sure is that being a rent stabilized tenant gives you a much high level of protection than being a regular tenant with a market rate lease or whatever type of lease. Tim, I know there's not a lot of questions. I think we're going really fast for these guys, and they're probably going to call us, figuring out what we were talking about. We have a bit of a shy crowd tonight, I think, or maybe they're just trying to digest everything, which is what I think is happening, and they'll call us later. But I have a question for you. If you do have a J51 rider, you've been receiving a J51 rider from the day one that you moved in. Um, can a landlord charge you a preferential rent while
Can the
having?
landlord, yeah, while having a J51,
Yeah.
I mean, the landlord could charge you a preferential rent, but under the new rules, under the HSTPA, if you're charged a preferential rent, then you have a right, as long as you continue your tenancy, to continue to get that preferential rent.
Mm-hmm, mm-hmm.
So, the J51 program may allow higher rent, or, since you're under stabilization, for example, if the landlord didn't charge you for a major capital improvement or for, a regular guideline increase, or the landlord said, I'm worried about losing tenancy here, so I'm going to give you a 10% discount or something like that, they can
Mm-hmm.
charge you preferential rent. And again, under the new rules, you should be protected to keep that rent on renewal.
Right.
And but again, the more troubling issue is if you get the rider, and you have it, you're stabilized through June 14th of 2019. What happens when the tax abatement comes to an end? The landlord has met all of their obligations, but my reading of the new law is that you still are rent stabilized. And that's a big change. It's a battle we're having. We'll be arguing it shortly in Supreme Court, and I'm sure it'll be going up to the appellate division and probably to the Court of Appeals at some point. But we need to keep those units within the stabilization system. This pandemic situation is going to change. The market's going to tighten up again. People need to understand that, and I recognize that many owners have seen some real disappointments and loss of tenants and loss of income, and that we're on the horizon of having a lot of non-payment proceedings, and a lot of things need to be worked out. But people need to recognize that for many, many years, for many, many decades, owners were collecting huge rent increases that were not warranted by the data, that were not warranted by operating cost data, or their costs for taxes and that sort of thing. But nonetheless, their net operating incomes were galloping ahead. Something like about 50% higher than they were back in 1990. And that's after adjusting for inflation. So owners were doing very, very well, while the relative cost to income, the rent to income ratio that tenants were paying, the amount of each of their, dollar of their paychecks that went to rent was rising over time to pretty unprecedented and burdensome levels. So our battle here has been to keep the rents low, and not lose the benefit of all of those years that we've been pushing. And the Rent Guidelines Board under Mayor de Blasio has been far more favorable to tenants. We were on the road to massive deregulation until de Blasio was elected and until the HSTPA of 2019 was passed. Now things have stabilized somewhat. But we do have issues on the horizon, and that is we have a housing and vacancy survey, which I expect will be done sometime in the spring of next year. And if the vacancy rate rises above 5% under the current law, we could face massive deregulation. I don't think that's going to happen. I don't want to frighten people because I think the state legislature will not allow a temporary spike in vacancies to undermine the entire system. I think some kind of legislative reform will address that. I think it would be insane if it didn't. But we are coming out of this. We're coming out of the pandemic, and I think the market will tighten up again, and we're going to see that kind of special privilege status that owners had in the past resume, and they're going to make their money in the long run.
Can you explain what a housing vacancy survey is? Who conducts it?
Yeah, every 3 years under the rent stabilization law, the city is supposed to take a survey of vacancies. Rent stabilization is, in theory, emergency legislation that's based upon a housing shortage that gives landlords undue excessive bargaining leverage when negotiating with tenants. The average vacancy rate in New York has been somewhere between about 2.5% and 4% over the last 50 years or so, which is a very low vacancy rate. Gives landlords a lot of power when they negotiate leases. Nationwide, throughout most of that period, the vacancy rate was about 8 to 10%. So you can see the difference. But in order to maintain the emergency assumption that underlies rent stabilization, there has to be a widespread and statistically significant survey of tenants. I think they basically look at about 18,000 apartments to get this large sample size. And they look at apartments that are vacant and available for rent to determine whether or not we've left this emergency shortage and there's a plentiful supply of available apartments, which would restore balanced bargaining relations between tenants and owners. The problem today is that the availability of apartments seems to be a temporary aberration. It's a momentary spike that's driven by a public health emergency, and it will probably come back into that tighter market within a few months. I would imagine, well, probably 6 months to a year, possibly a little longer. So it's always been my position that given the fact that this appears to be temporary, the state legislature should require 2 consecutive triennial every 3 years, 2 consecutive surveys showing a vacancy rate in excess of 5% before they implement any kind of a deregulation scheme. There has to be clarity that if there is a lot of housing, then we will be able to bargain and find reasonably priced housing. And I know there are people who disagree with me to some extent. They think that we should treat the housing market like a public utility with a fixed rate of return and that sort of thing. And I have, I certainly would welcome that result. I just don't think it's politically tenable in this particular period. So my position on this, and I know I'm going out on a bit of a branch here, is twofold. One is make sure the vacancy rate is, vacancy survey is done twice over a 3-year period before any determination is made as to whether or not we should have deregulation. But secondly, and equally, actually more importantly, there should be a universal protection for every tenant, not in the city, but in the state, against unjust and arbitrary evictions. So everybody gets a right to a renewal so long as they're paying their rent, they're not creating a nuisance, or they're not abusing their apartment in some fashion. And protection against unconscionable rent increases, which would be something like 1.5 times the consumer price index. So a landlord cannot squeeze you out of your apartment by imposing an unreasonable or excessive rent. So if we had a protection against unjust evictions or arbitrary evictions and a protection against unconscionable rent increases, that way everybody in the state could be protected, but landlords would have a considerable degree of flexibility within that system, to increase rents over time and to pay their bills and so on. It would be a far simpler system, more robust. It would require more involvement on the part of the courts than on administrative agencies. But I think that's the minimum floor that we should have in the 21st century for people who rely upon their rental units as their homes. And in a city like New York, where 2 out of 3 residents are renters, renting is the norm. That's the reverse in other areas. Typically, it's only about a quarter to a third of the households in other cities that are renters. But in New York, it's a very large percentage. And people need stability in their lives. They attend churches, they attend part of social clubs, they have their kids in schools. They're long time residents of their neighborhoods. They may have local businesses. So having that stability in the household is critical. They should be protected as long as they're paying their rents, and as long as they're not breaking reasonable restrictions on their use of the apartment, like creating a nuisance or using a protected apartment as a pied a terre when could be used by somebody else who may have greater need for it.
Yeah. Well, this is terrific. I think I'm going to pass it to Robert, but I have one last question. I probably should have asked you this before we started. You were one of the first attorneys out there, right after the new rent laws were passed. It's like LCA, first rent. You remember that?
Oh yeah.
So could you talk a little bit about first rents, and then can a landlord, assuming the landlord will combine these apartments, can a landlord that has a J51, can they go ahead and discriminately just charge whatever they want? Can you elaborate on what first rents are? And because I know that there are some concerns, especially with the warehousing.
Yeah, well, there are a number of layers to that, but let's talk about, first of all, again, if you've been protected by J51, you're in occupancy in June of 2019, you should remain stabilized through the life of your tenancy. And even on vacancy, the unit does not come out of stabilization. There is no more vacancy allowance that used to be allowed. And the amount of an increase the owner can get for an apartment improvement is a far smaller figure than it used to be. So the unit should be continuously under stabilization and the rent should not go up all that much. Here's the exception. If the apartment becomes vacant, so this would not affect tenants in occupancy, this is a newly vacant apartment, and the owner reconfigures the apartment, and in most cases, this requires that they obtain a new certificate of occupancy. Very important. If the building is occupied in a manner that is inconsistent with a certificate of occupancy, which specifies the number of units for the building, then you have a complete defense to having to pay rent. The owner under the multiple dwelling law cannot collect rent, cannot bring a non-payment proceeding if there's a non-conformity with a certificate of occupancy. It's one of the tenant attorney's most powerful tools. And every tenant should be aware that you can check your certificate of occupancy on the Department of Buildings website and determine whether or not your building is properly occupied. So if you are in a building and again, you're stabilized, whether it's by J51 or just longstanding stabilization, you don't have anything to worry about. Here is how owners get out of the system. If the owner subdivides the apartment or combines the apartment, and I'm not talking about or shifts the parameters of the apartment. I'm not talking about a small adjustment, like bringing it in 2 or 3 feet. I'm talking about a real significant adjustment where, a whole room is attached to another apartment, or the whole apartment itself is divided in half, or it's combined completely with another apartment. In those circumstances, the owner can charge what is known as a first rent, which means that they treat it as if it's a whole new creature, and the rent is set at basically a market rate. However, okay, It's not deregulation. It's just a new first rent under the rent stabilization system. And if you go on Palante's website, I guess I'll see if you still have that piece that I wrote still up there. There are arguments to be made under the new law that this first rent system is questionable or should be revised and reformed. But the basic rule is that you could see in a rent history, for example, that an apartment which was once renting for $1,000 a month is now renting for $2,000 a month, even though the apartment is only half the size that it was when it was renting for $1,000 a month. That may be legal. That is the first rent loophole, and that's the name of the game. I'm sure LC, you've seen it uptown, and it's happening throughout the city where owners, get a lot of vacancies, and they make duplexes, they split apartments up, they combine apartments, et cetera. So we will see more of that, I'm sure.
Yeah, right now they're warehousing in hopes that we would vacate the apartment next door so that they can do that. So we're staying on top of it, and anything, and if anybody on the line see that the landlords are engaging in that, in the warehousing departments, feel free to drop a dime at Palante, and at least so we can start monitoring it. I'm going to Tim. You're terrific. I think you and I can sit around and we could talk about this for hours, but I want to make sure you come back and continue to help us. Okay, so I'm not going to abuse your time.
We do
I
have a
wanna
couple
pass it-
questions.
I'm always good.
Thank you.
You're
I'm gonna
terrific,
pass it
LC.
over to Robert.
Okay.
We
Well,
do
let
have
me
some
just say
questions
this.
trickling in. Yeah, I'll go ahead.
Okay, good. No, I just want to say, Alcia, you're always full of compliments, but you're terrific. You're
Oh, thank
outstanding.
you. Thank you, Tim.
You are a diamond. So I'm sorry, Robert, go ahead. So we have
Yeah.
a question.
If a building
Go ahead.
has changed numerous landlords in a period of years, would it affect the J51? Current landlord claims there's no funds for repairs like sealing the outside walls to prevent mold, yellow peeling paint, and water leaks inside the apartments.
I'm not sure what the condition has to do with, J51 is something that you can use to get an additional benefit if you're doing capital improvements, which may help remedy some of those problems. But a landlord, if they're in the business of renting apartments, has a legal obligation independent of whatever their financial condition is to make sure that the place is habitable. And the habitability of the apartment is directly connected with the obligation to pay rent. And if an apartment is uninhabitable or you're suffering from leaks and mold and other conditions which affect health and safety, then there are a number of ways to address it. One is to bring an HV action. I mean, the first step is to call 311 and have an inspection done. You can call Palante as well to get more information. I should say probably the first step, if it's a minor issue, is to call the landlord, and ask them to correct it and keep close records. If you're emailing, keep your emails. If you're calling, make a note of when you called and who you spoke to. And if you're writing or sending letters, certainly keep a copy of the letters that you send. Let the landlord know there's a problem. Tell them when you're available to be there to have it remedied. And that's another really, really important thing. The most consistent, underhanded, frankly, slimy game that owners play is complaining that tenants are not allowing access to fix bad conditions.
Yep.
If a tenant says, look, I got a dentist appointment that morning, I can't let you in. They'll say, oh, no access. We wanted to fix it, but we got no access. And sometimes they'll just make it up. So you have to really go out of your way to be available to the owner and to document that you made the offer and that you stayed there at the time that they were supposed to be there. And that they had complete access, so that they can't pull that, kind of excuse. And once you've given them access and they fail to do it, or once you've written to them and they fail to take any action, then you can call the city 311, ask for an inspection. If it's a serious condition, HPD will send inspectors down. The other thing you can do is, and bless you, Alcia.
Thank you.
I'm gonna try and catch you between sneezes here. But Alcia, do you have a copy of the tenant checklist for bad conditions?
I do,
at
I do, and
Palante?
it's on our website as well.
Yeah, okay, so it's a wonderful thing. There's a list of all of the things that you can review in your apartment. Do your windows open and close? Are you getting leaks in the around the faucet or around the toilet or around the kitchen sink? Do you have mold? Do you have loose tiles that somebody can trip on? You have locks that don't work. You have loose electrical plates or hanging wires. You have broken plaster and no paint in the last 10 years, that kind of stuff. You can go through the list, the checklist, and get it on the Palante website. And then you can basically call that into 311, make your complaint. And if you can't get an HPD inspection, if it's serious enough, then you can think about bringing again what's called an HP action. HP action is a way to get the city to enforce the housing maintenance code. It is not so much about your warranty of habitability. It's about ensuring that the public interest in having safe and habitable buildings is met. But if you want to assert your warranty of habitability, then you have to think about things like withholding rent, going on rent strike, and so on. It's a much bigger issue, and it's really not connected with J51. There was a time when we advised almost no one to go on a rent strike or withhold rent because of what was known as the blacklist, insofar as it could be used to discriminate against you in the future. That probably still happens to this day, even though under the new law, owners are not supposed to discriminate against tenants based upon, past litigation with prior landlords.
What we'll do is we'll forward as a part of the follow-up to this, we can forward the link to the inspection checklist. One thing, Tim, that you forgot to mention, which a lot of people forget, but our staffers, when we go into people's apartments, the first thing that we look for is the self-closing doors.
Yes.
Yeah, that
Yeah,
presents a
very, very important. Very, very important. Self-closing doors are critical as a protection against the fire hazard. When those doors are open, if there's a fire going on in the apartment, it can turn into a very quick and very dangerous condition. When those doors are closed, it will keep things moving more slowly. There are other things that are fire hazards people should be aware of. You should never, ever have what's called a double cylinder lock in your front door. That is a lock where if you remove the key, you cannot open the door from the inside. Extreme fire hazard. The other thing is, if you have a window gate that has a lock that can be, where the key can be removed and you can't get access to a fire escape if the key is removed, another very extreme hazard. So there are lawfully designed window gates for fire escape windows, and you should have a lock on your front door, which is a latch, and not one where the key is removable, which is extremely dangerous.
We have another.
But yes,
more questions, Robert?
Yeah, someone posted. At one point, I recall reading something regarding rent stabilized tenants and the terms surrounding 20 years plus and being a senior citizen, that rent increases would cease. Have you heard or have any knowledge of this concern?
we're actually mixing up a couple of different rules that are complicated and are now kind of moot under the new HSTPA. The 20-year rule and the senior citizen status used to apply. It was senior citizen applied across the board, rent stabilized and rent controlled, against owner use eviction proceedings. And senior citizen status also was, I'm sorry, the 20-year rule itself also came into play if you were rent controlled. In general, the benefit of being a senior citizen is that if you have a relatively low income, and by that, I don't know the exact amount, but it's over 50. I think it's either 50 or over 50,000 now. If your annual income is less than 50,000 or whatever the threshold may be, you may be eligible for a senior citizen rent increase exemption. And that begins at age 62, and that's probably what the caller was referring to. And the way to get information about that is to go onto the Department for the Aging website I think they still manage that program. You should be able to get that, or else call Palante. I'm sure, Elsia, you have SCRI and DRE recipients if you're
We do.
disabled. Yeah,
Yes. Yes.
even if you're not 62, but if you're disabled, you may have a protection against rent increases.
Yeah. As long as your rent is a little bit over, is 30% or more of your income,
Right.
and you're 62 and you make no more than $50,000 a year of income combined, we'd be more than happy to help you guys fill out the application, which is fairly easy. And the idea is that it freezes the rent to the level of when you apply. So any, any MCIs, any additional increases, they're given to the landlord in the form of a tax abatement. So it's not like the landlord, it's not like Section 8 where the landlord gets an actual check. It's actually where the landlord just, is a tax abatement. He gets an abatement into his taxes, his annual and quarterly taxes.
And last but not least, what about tenants that have housing assistance? Are they at jeopardy for the J51 if they lose their assistance?
I mean, J51 really determines the rent stabilization status. I don't know that it's not generally not involved in a program. I mean, 421A does have some designated, affordable, has some buildings with designated affordable units, which is kind of a whole different thing. But under J51, if your owner did receive a J51 abatement, you should be under rent stabilization unless it was deregulated prior to June 14th, unless it was lawfully deregulated prior to June 14th of 2019. Yeah, it's not a means tested situation.
Yeah. I think that the program that the college probably referring to is something like, maybe FEPS or any sort of government rent subsidy program. They usually have different criterias. But what Tim is saying is that the J51 sticks to what the landlord has to do in terms of making these apartments affordable through rent stabilization. So here on this slide, we have a couple of things. First, we've been talking about uh, requesting your rent registration history. So the first number you see on the slide, if you want to get a warm body at DHCR, these are the people that oversee the rent laws. You would call 212-961-8930. For those of us who are having a rent burden and we're behind on our rent, the place to call right now is actually applying with HRA for a one-shot deal. The slide shows the rent relief, but that's actually closed already. But if you are behind on your rent, it's really easy to apply, folks. You don't have to be in court to apply. You could call them at 718-557-1399, or you could just use this hyperlink here on this slide. Robert, if you could put that link, the Access HRA link, on the chat,
Absolutely.
as well as the DHCR, the second one, the human resources one. So the folks that need to use it, they can just copy and paste it. And then last but not least, Tim, before we let you go, can you give us a quick update what's going on in court these days? I know we're bracing for May 1st, right? But it would be fair to say that if anybody received any court documents, everybody should be filling out the hardship form. Is there anything else any advice that you could give us?
I really can't at this point. I'm not sure. I mean, I think it's a political process. I think we just have to watch what's happening very closely in Albany and in Washington. Hopefully people will be getting checks soon from the new programs. There are a number of things that I have personally supported, and I hope that they'll pick it up in Albany. One would be that for anybody who has a serious back rent issue and was affected by COVID, the owner should not get an eviction, but maybe get a money judgment that could be dealt with over time, and hopefully not even a money judgment that's going to impair somebody's credit, but a special category, sort of a COVID related money judgment, sort of like a healthcare kind of debt, which has special protections under debtor laws. So hopefully, either the federal government or the state will come up with something so that people can stay in their homes and then deal with the debt over time. It's going to take a while, and nobody should be, some people have been completely derailed financially, and to expect them to pay, a year of back rent or even 6 months or 3 months for some people is an extreme hardship, and hopefully there'll be a reasonable and uniform way to resolve it. But the first, line of defense should be no evictions, no evictions. If they get a money judgment, they get a money judgment, and allow people to work off those judgments over a long period of time.
And another
But I would add that if you end up in court on any of this stuff, you should be able to negotiate something with the owner. I think most owners will probably be, I'm not going to say reasonable, but at least open to solutions that ultimately resolve the debt without an eviction.
Are added fees for owning a washing machine or late rent payment charges legal on a rent stabilized apartment?
The fees are limited by law. Adding fees for washing machine, if on a washing machine, if it was in existence at the time you took the apartment, if it's part of the required or ancillary services, they should not change with the lease. So the answer to that, no. If the washing machine is added as a service, that's a different issue, and I really refer you to Palante to look into that in detail. I think it depends on the circumstances. And I know that late fees are limited. I don't remember the exact numbers. I rarely get this issue, but I believe the new law addressed that as well. So it's not an open-ended thing. They are limited by law. And I know, I wish we had a screen we could put up the limitations, but I don't have it.
Yeah, but I think in general, it's that if you had a washing machine and the landlord did not charge you for it before, he cannot come now all of a sudden that he found out you have a washing machine and charge you for it. And then when it comes to the late fees, I'm not an attorney, so Tim, let me know if I'm saying it wrong, okay?
Well, I mean, there may be some argument that if the landlord offers to install a washing machine, they might be able to get an individual apartment improvement increase, which are themselves really quite low under the new rules. They're a little complicated, but if you want a washing machine, you don't have one, and the owner says, "Look, I'll give you one, but you're going to have to pay a few bucks extra each month for it." As long as they stick with the individual apartment rules, then that's probably legal. If there's, in terms of imposition of additional electrical charges or water usage, I'm really not sure what the rule is on that. It's a question I almost never get.
And then in terms of the late fees, it has to be on your original lease, right? Still, the things change.
Right, they cannot, but the original lease could allow for, like a 10% late fee.
Right.
That would not be enforceable at law. That would be considered excessive. But again, I'm quite sure that the HSTPA, and I'd have to look it up, addresses this and limits the amount of late fees.
Okay, wonderful. Robert, do we have any more questions?
I think another one popped up. Let me just take a look.
Tim, I'm sorry, you were about to say something?
No, I was just going to say that's something that we could talk about. Alcia, just so Palante has the actual legal provision from the new law, and you have it handy for people who call in. But I think it's probably buried within the text of the HSTPA, which is this thing here. So I don't think I could find it in short order. But go ahead.
If a J51 building installed gates to the fire escape, and at this time, as a senior, the old accordion gates are hazardous, gates are not suggested. So does the landlord have to replace broken and or dangerous, as the senior cannot climb over the gates for escape in case of fire?
Yeah, I'm sorry, you froze in the beginning of that question, so you'll have to give me the.
I can repeat that. If a J51 building installed gates to the fire escape, And at this time, as a senior, the old accordion gates are hazardous. Gates are not suggested. So does the landlord have to replace broken and or dangerous, as the senior cannot climb over the gates for escape in case of fire?
Well, anything relating to fire is very closely regulated. And that's the kind of question, if you want to find out whether or not the gate is legal, HPD, the fire department itself can answer it. But anything that creates a hazard, no matter what it is, if it creates a hazard, is something that is arguably at a minimum a violation of the housing maintenance code, but is most likely also covered directly by the fire code. So that's something I would raise at 311. And let me emphasize this, because I know there's a lot of people who go, it's a fire thing. I'm not going to have a fire. Fires are rare. They only happen once in a while. When fires happen, people die if they're not prepared for things. So if you see a significant thing that's a fire hazard, like Alcia mentioned, self-closing doors, which are vitally important, that's something that should be attended to. And I know some buildings are configured. Sometimes landlords stick people in basements that are illegal. Some basements can be legal if there's a second means of egress and if other issues are dealt with. But there are people who live in dangerous fire traps in the city. And if you happen to be living in a cellar or a basement that is not legal, then first of all, you don't have an obligation to pay rent, because I'm sure it'll be in violation of the certificate of occupancy. But secondly, you ought to find a new place to live very quickly.
And also, Dim, that we came across one building where the landlord was doing a lot of rehab in the building on individual apartments, but he didn't have any permits. And when one of the tenants called 311, it actually resulted in the Department of Buildings issuing stop work orders because the owner was creating a fire trap in these apartments. So yeah, I mean, it's always good, to turn on the side of caution and call 311 and speak to an operator, and they'll direct you to the right agency where to file the complaint, just so that we can feel safe and know that somebody that knows the regulations around the specific issue can come over and just address it. So, Tim, thank you so much. You're terrific. I mean, I can, again, we and I can spend hours on this because you're just a wealth of information. I wanted to thank you for being on our call. We're now going to check the survey, and for everyone on the call today, we're going to make sure we do three things. We're going to forward you a copy. Jacari, make sure we do this, right? So we're going to send a copy of the individual apartment checklist. We're going to send you a copy of the first rents white paper that Tim Collins authored for us. And third, we're also going to provide you the cliff notes of the rent laws for the 2019 cliff notes. And we'll get that to you electronically. For those of you that are on the phone, if we do not have an email for you, we'll surely add you, actually put a copy in the mail for you. But again, thank you so much, Tim. Thank you, everyone who is on this call on Friday nights, where we're here learning. And if you don't know, just take a few minutes of your time to complete the survey. Wait, Robert is texting me. What happened, Robert? Oh, we have another question, Tim. Do you mind sticking around for one more question?
Yeah, that's fine.
I don't know how on topic it is. Hello, my initial lease late fee says $20 after the 10th of the month, and the HSTPA says 5%, but no more than $50 after the 5th day, which would apply to me.
It can't be more. It can't be more. I'm just checking it now because I remembered the number was in there, but I didn't have it in front of me. It cannot be more than $50 or 5%, whichever is lower. So if 5% is lower, then that's the amount they can charge. So the $20, if $20 is lower than 5%, then they can charge the $20. And that's it. Whatever is, in other words, if your lease specified more than $50 or more than 5%, again, whichever is lower, your lease would not be enforceable. under the law. But if your lease specifies something less than 5% or 50, again, whichever is lower, then that's what the owner can charge.
Thank you. And you're muted, Elsia. Elsia, you're muted.
Yeah, keep on unmuting and muting myself. My apologies. So I wanted to just once again thank everyone. Thank Tim for being such a wonderful partner. We hope to have you again. We really enjoy you here, and thank you for, just spending time on a Friday night. I mean, you're a private attorney. You're over here helping us out, helping our community out, and that to me means a lot. For everyone on the webinar, if you could just take a few minutes and complete the survey. As always, we want to bring the best survey, the best webinars that we could bring to you with the best subject matter experts that exist in New York City, Tim Collins being one of them. If you could just take a few minutes, and hopefully, we'll see you next Friday. Next Friday, we will be talking about how these are for people that are focused on becoming first-time homeowners. So if you're looking to buying an HDSC, a low-income co-op, we're going to have the credit union, the Lower East Side Federal Credit Union. They're going to teach us how we could go about doing that. If you know anyone that is interested in buying, there's renters and there's homeowners, right? And there's shareholders. So if you know of anyone that's interested, if you're interested just to learn how and help educate your neighbors, help educate others, feel free to join us next Friday. And then we'll continue, as always, with every one of our Zoom calls where we bring you an update regarding COVID, as well as what's happening in housing court. And again, if you receive any documents from the landlord, from the court, please reach out to us. We'll get you the hardship declaration form. We'll fill it out for you, and we'll help you mail it as well to make sure that it makes it to the right place. We don't want anybody here facing eviction, and especially those people that are spending Friday night with Palante. So thanks again, and have a great weekend, everyone.
Thank you. Bye-bye.
Thank you.
Bye-bye.